69, correct? All right. All right, sir, come on up and have a seat right in the chair. All right, you are Juror 69, is that correct?
That is correct.
All right. First thing I'm going to do is swear you in so that all your answers are under oath. If you could raise your right hand. Do you swear or affirm, under penalty of perjury, that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. Just a note here, I'm going to continue to wear a mask. You have plexiglass between us, plexiglass in front of you. The attorneys will be at the lectern with plexiglass in front of them. The conclusion being, if you would like to remove your mask for more comfort or to speak more clearly if necessary, feel free to do so. Okay. But it's pretty much your choice. Okay? In either case, mask or not, if you could move up closer to the microphone so that we can pick up your voice nice and loud. Perfect. Well, first of all, before I turn you over to the attorneys, I have a few questions of my own. Starting with, you filled out a questionnaire, and thank you for doing that and getting back to us. It gives us a lot of information. Is everything on that true and correct?
It is.
All right. Any changes or additions to the questionnaire?
No, I don't believe
so. And it's very important that you understand that it's okay to do that because you filled this out months ago. In the meantime, you might have reflected on things and realized, I should have said this, or that was inaccurate, I need to correct that. Or even some of your opinions may have evolved and changed. So,
oh, sure.
If you say anything that's different from the questionnaire, that's perfectly fine. So don't worry about that. Now, the questionnaire also advised you not to read any media, to avoid the media about this case. But we also recognize it was a couple months ago, and inadvertently you may have been exposed to some media, some headlines, maybe a news blurb before you were able to change channels, something like that. Did that happen to you? Did you get exposed to some information about the case?
Yeah, I would say scrolling through like Instagram or something, I would see headlines maybe about just like the recent news of like Minneapolis paying out to George Floyd's family.
Okay.
And then something about a third-degree charge, but I kind of skipped past that. So.
All right. Talk about the third-degree part first. You don't recall any substance other than it was mentioned? Did you?
That was pretty much it. That there was, I read like the Chauvin case and third-degree charges were brought up, and then jumped past that.
Okay. Now, as far as the thing from last week, what specific details do you recall?
Just looking through, let's see, it would have been Star Tribune saying payout $27 million, or something like that.
Okay.
To the family.
Now, you understand that was a civil case, different parties, different legal issues, different laws, and really has no bearing on this case.
Right.
But even though from a legal point of view, everything I've said is true, do you think that would make it hard for you to be impartial, or does that push you one way or the other in this case?
Oh, no, it doesn't.
Okay. Can you put aside what you heard and just decide this case on the facts and what you hear in the courtroom?
Yes.
And that's true generally of everything, because everybody, that's why the first question we asked was, what have you heard? Everybody has some knowledge about the case. Some is accurate, some is inaccurate. But whatever you've heard about the case, and I'm sure most people have formed various opinions related to those, what they've learned, you have to put all that aside. Decide this case just on the evidence, objectively, and apply the law as I give it to you. Despite being exposed to some things, do you think you can decide this case objectively, fairly, and above all, impartially?
I do.
Okay. Can you put everything else aside?
Right.
Okay. Did you decide, or did you recognize any witnesses that were on the list we gave you?
I did not.
Okay. We have estimated that the trial is going to be about a month long, starting March 29th. essentially start then and go for 4 weeks. Does that work for you personally, professionally?
I mean, it's just getting into the busy part of my job.
Okay.
You know, we have projects ramping up, but I'm sure that's something that we could figure out.
Okay. And it's more a question of can you make it work, because we know that there's a certain burden on everybody for jury duty. And we appreciate that, and we try and accommodate if it's an extreme hardship, but it sounds like you can make it work?
Yes.
All right. All right, then, unless you have any questions for me.
I do not.
All right, then I'm going to turn over the attorneys. With regard to Juror 69, Mr. Nelson.
Can we have a brief?
Sure. I'm just going to talk to the attorney. All right, Mr. Nelson.
Thank you, sir. Good afternoon, sir.
Afternoon.
Before I kind of go into the questions I have for all of the jurors, I just wanted to follow up a little bit in terms of your knowledge about this recent settlement that was paid out or is to be paid out by the city. If you were in the jury room, right, and people are kind of, you know, they're discussing guilty or not guilty, would you in any way bring up that settlement as, you know, hey, look, the city agreed that there's some liability here or whatever? How would you take that information into the jury room?
I mean, I guess, you know, if it's not something that should be part of it, I just wouldn't even bring it up.
You wouldn't even bring it up?
If it's not part of this case, then I wouldn't, you know, it doesn't have a spot in it.
Well, I think what we're telling you is it's not a part of this case. It's,
Right.
It's a different case,
Right?
different legal standards. Do you
Right.
understand that?
I understand.
Okay, and we just need to make sure that we're not going to have that information in some way affect the judgment in this case.
Right.
And you can do that?
I can do that.
Okay. All right, sorry, I just wanted to explore that a little further before, we don't want to waste anyone's time.
Yep,
obviously.
makes sense.
So I'm going to ask you a series of questions generally, just to get to know you a little bit better, and then I'm going to ask you some specific questions about some of your answers on the questionnaire.
Sure.
Again, we understand that it's been some time since you filled this out, and I'll read you your responses. We're not trying to trick you, okay?
Okay.
All right. So if you and I were to meet at a party or some sort of a social event, and we had our first conversation, what are a couple things I'd learn about you in that conversation?
Pretty much, I just love doing anything outdoors. Avid fisherman. I mean, you name it. Just hard worker. Want to be outside.
Okay,
That's about it.
fair enough. You avid fisherman, you said?
Yes, sir.
Okay, like most Minnesotans, right?
Yeah, you gotta.
All right. I'm going to ask you, because of the mask, and you may need to come a little closer to the microphone for me if you don't mind, because I also have kind of
Sure.
bad ears. Thanks. So at some point you received this packet of information, right?
Yep.
And you learned that you were a prospective juror in this case. And you'd obviously heard about this case before. You knew that. So what was your initial response to this jury, to learning that you were a potential juror in this case in particular?
I mean, I wasn't really excited about it, just given the kind of global scale that it has reached. Wasn't really looking forward to it. I don't know.
You said you were not looking forward to it?
Right.
Okay. I think you ultimately expressed some concerns about safety. Do you remember that?
Yes, I do. Just concerns about, either way, whichever this case would go, and again, the popularity and how extreme things, had happened after the event, that it makes me a little concerned.
Okay. So let me ask you, when you got to the government center this morning and you saw the fortifications and preparations around the government center, how did that make you feel?
Very secure, actually. Yeah, it looks.
Okay.
It looks good.
And how about this morning when the judge kind of told you that your video or your face isn't going to be shown if you were a juror? We're doing what we can to protect your anonymity. How did that make you feel?
Yeah, it makes me feel better. I mean, I trust that that's what's happening. So.
Okay. And if you were to, it's entirely possible that at some point in the future your name would be released publicly if you were to serve as a juror in this case. How does that impact you?
I mean, I'm aware that would happen. I would just hope that it would be after a period of time where things can kind of cool down a little bit, and maybe not so much press about it. Do you have? You understand there's two potential outcomes of this trial, at least theoretically, right? Right.
A guilty or not guilty verdict.
Right.
Do you have more concerns if the verdict were to be one versus the other?
Yeah, I suppose I would if it was not guilty.
And do you think that that would in some way affect you and how you may choose to vote in this case?
No, I mean, I'm kind of like do the right thing and kind of try to live by that code. So.
Okay, and I'm going to ask you a couple of other questions about that once we get to your questionnaire. Can you think of a situation in your personal or professional life where you've been called upon to resolve a conflict between two people?
Maybe not like called on for like a verbal debate that something's happening.
Yeah, you got two friends, they're disagreeing with each other, and they turn to you and they say, Juror 69, help us resolve this dispute.
I would say not really, no. If they are in front of me having a dispute, I would say like, let's break it up, or.
Right. So you understand, if you were to be a juror in this case, ultimately there's kind of global big disputes, right, in terms of is it a guilty or a not guilty verdict. There's a dispute between Mr. Chauvin and the state of Minnesota here right now.
Right.
I understand that. And you'd be called upon to potentially resolve that dispute.
Right.
But then also within the jury room itself, right, you got 12 citizens, and there may be disputes about the importance of evidence or testimony. So how would you picture yourself simply approaching the task of resolving a dispute?
I would lean on evidence that was brought up and try to stick to facts and just be like, let's look at this and tackle this piece of evidence and weigh it and see, like, how does this affect the outcome here? Okay.
So let's say, for example, that there was a particular piece of evidence, right, that you felt, this water bottle is the answer to this dispute, to solve this dispute. And other jurors thought, that's nothing, it's just a water bottle, right? How do you kind of reconcile or get to the bottom of whether that piece of evidence is important or not?
I would have to rely on any notes I took and say, like, hey, I really think there's something here. It's worth discussing at least, and we need to come together as a group to at least address that this is an issue.
Okay. And what about if after that process of doing that, you were still convinced it was important, but the others weren't? Are you the type of person that's going to agree with the majority simply because you want to build consensus? Or are you going to stand your ground and say, no, we really need to take this into consideration?
I think after, we had all talk about it, that if the group votes on it, then it's a dead issue there.
Well, I guess that's sort of the question, isn't it? Any verdict has to be unanimous.
Right.
Right? And if you really believed that
Right.
that was important, are you going to just abandon your belief about that piece of evidence simply to reach an agreement?
No.
Okay. Are you willing, however, to re-examine your beliefs about the evidence or the material that's presented in court?
I would say yes, I'd be open to re-looking at that.
Okay. Can you think of a situation, again, in your personal or professional life where you have been called upon to determine whether someone is lying about something?
Yeah, no, I don't really get caught up in that.
Probably not?
No.
Okay. So, as a juror, as the judge mentioned earlier, is one of your roles is to assess the credibility of witnesses in this case. And it's a fancy way of saying, do we believe this person, right? How would you approach the analysis of whether someone is credible or not credible, whether they're lying or not?
Geez, I don't know, that's a good question. I just try to listen to what they have to say, basically, and I don't know, just determine based off of cues of, how they're acting, or I guess first and foremost, I would just listen to everything that they have to say. And
Okay. So let's take it a little bit perhaps broader. You have two witnesses, right? And think about this in the proverbial sense. There's a traffic accident, and the issue was the light green or the light red, right? There's two people standing right next to each other, watching the same thing, and one person says the light was green, the other says no, it was red, right? So how can you kind of picture yourself trying to determine? They're both convinced, right? They both see it from their perception. They're standing right next to each other. It's the same event. How do you weigh which one to assign credibility to?
I don't think that would be up to me in that scenario, and I understand the point of the question here is, to determine if I would be able to. But if I was coming into that scenario, I would first just be like, I'm a very trustworthy person, so I would say, look, I'm sure that's what you saw, and I'm sure that's what you saw, but I guess I wouldn't put myself in the spot to say you're right, you're wrong.
Okay. Ultimately, as a juror, you're a judge of the facts, right? And in a case like this, you may have two people who are observing the same incident from the same general perspective, right? Mm-hmm. And they may interpret that event differently. And it is your job as a juror to decide. So, do you think you could do that?
I might have lost you there. I guess I don't understand if I'm able to, based off of facts, and then say, if I was yeah, I can see that based on this evidence that yours was green, I could say, look, you thought it was red, but it was green.
Okay. So
if that's what you're asking.
That's what I want to kind of ask you is, you can look at the other evidence that may support one side or the other side. Right? And you would be able to assess and judge the facts of this case based on all of the evidence, not just one single person.
Right.
Okay. Can you think of a situation in your life where you have been 100% convinced that I am right, only to later learn that you were in fact wrong?
I mean, mine are day to day. My wife's always right, so I lose that battle. But you know, I'll think that I'm right on something and then forget, or yeah.
Okay.
Not on like a major. Well, go ahead.
I understand. You know, I think someone referenced like a sports statistic, right? And you may think about like, I'm 100% convinced that this athlete had this stat, and then you look it up and it's like, oops, I'm wrong.
Right.
So are you the type of person that kind of learns from that, applies it in future situations, or are you the kind of person that goes, it's not that important?
No, absolutely. I'll constantly learn from those.
All right. Again, ultimately, your role or your job as a juror is to listen to the evidence, listen to both sides, listen to the entirety of the case, and at the end of the case, the judge will present you with some rules of law that you have to apply. Are you the type of person? Well, let me ask you. Rephrase that. Will you follow the law as the judge instructs you, even if you think it is wrong or should be different?
Yes.
Okay. So I'm going to ask you some questions again on your questionnaire, not trying to trick you, not trying to suggest you're not telling us the truth, right?
Sure.
We have to take you at face value. We don't know what's really in your heart or in your mind, right? So the first question that you were asked is just a general recitation of what you knew about this case based on what you had heard or seen prior to filling this out. And I have a couple of questions about what you wrote. One of the things you wrote is that you saw a video through social media, and you wrote, "The footage was pretty clear, and I recall a woman's voice pleading with officers to ease up on George, saying he can't breathe." What do you mean by the statement, "the footage was pretty clear"?
You could see, you can make out the officers, and it was just clear video in terms of resolution, I suppose.
Okay.
And just the general sense of what had been captured that day, like on the footage.
Okay. And I'm going to just skip forward a little bit. I just want to make sure we're talking about the same footage, right? You understand, or there was a bystander who took a video of Mr. Floyd's interaction with Minneapolis Police Department. That video was uploaded to a social media platform, went viral, and became news.
Right.
Is that the video that you recall seeing?
I only saw the video footage from pretty much the kneeling stance on.
Did you say the media stance?
Yeah, I guess. No, not the media, like the Facebook video that was out there.
Okay.
I didn't see the interaction before George was detained.
Okay.
Only from that point on.
Okay. So just the only video you've seen is that bystander video that went viral and became a part of the news.
That is correct.
Okay. Not seen any of the body cameras from the officers or security cameras that may have been entered the public sphere?
Right. No, I have not.
Okay. And I think you said you had seen that maybe 2 to 3 times in whole or in part.
Just in part, clips, a couple times, yeah.
You never went and looked up the original video and watched the entire video?
No, I did not.
Okay. And then one of the other things you wrote is that as time progressed, the media started to change the verbiage from, and you put in quotes, the death of George to the murder of him. Or can you just explain what you mean and what impact that had on you?
Yeah, it just seemed like, and again, I pretty much just had been looking at headlines up until the point about finding out about being selected, that a lot of different media sources were saying that it was either the death or it slowly turned into headlines saying like the murder of, and that just grew more and more over time, it seemed like.
Okay. And that is, it's fair to say that you sort of adopted that perspective for yourself, right? That opinion?
I mean, I get that it's not up to media to make that decision. That's what we're here for. I don't know.
Well, and sir, let me just assure you that your opinion is your opinion, right?
Yeah.
I'm not questioning your opinion. I need to know, and we all need to know, the extent to which your opinion may bias you against either party, whether it be Mr. Chauvin or the state of Minnesota. Do you understand that?
Yes.
Okay. I mean, and ultimately in your questionnaire, you were asked if you had had conversations with your friends and family about this incident, right?
Correct.
And you were asked to share what opinions you had expressed, whether it be with friends and family, and whether or whether it be on social media platforms, right? And what you wrote was George Floyd had been murdered by police officers.
Right.
So you formed the opinion, right, that George Floyd was murdered by police officers.
Right.
So, you know, kind of go back. I mean, you adopted that stance that the media had kind of changed, right?
Right.
And you were asked in the questionnaire a question of the impression that you had of Mr. Chauvin based upon what you had seen and heard, and you wrote that you had a very negative impression, right?
Right.
And you wrote that from the video footage and people pleading for George's life, the defendant didn't let up.
Right.
So ultimately you understand that as we sit here, based on the presumption of innocence, right, have you already decided this case in your mind?
You know, I think that as all those headlines are coming through and, you know, maybe subconsciously adopting them or I have adopted them, as you're saying, it probably was easy for me to just say, like, oh, have you seen what the news is saying?
Well, I mean, in the questionnaire, there's a question that asks you about the application of the presumption of innocence.
Right.
And I think you said, in this case, based on the footage that you've seen, that it would be very difficult for you to presume him innocent. Would you agree with that?
Right, yeah.
And so, again, the question being, right, you have formed a strong opinion. It is your absolute right to do so. Whether it's your opinion, you're based on the media, whether it's your opinion based on conversations with friends, you are entitled to that and it's okay. Can you honestly say, I can set all of my opinions, my very strong and negative opinion, I can apply the presumption of innocence, and I can listen to this case based on the evidence in court? Can you say that?
Yeah, I think it's a really tough thing for me to do, but I also think digging into like who I am and saying like set that aside, listen to evidence, because it is such a huge case that we need to do what's right, that I think I can do that.
Okay. Can you foresee a situation where what's right to do is to find Mr. Chauvin not guilty?
Can you say that again?
Sure. Can you imagine a situation where the right thing to do is to find Mr. Chauvin not guilty?
Yeah, I have thought that through my head, like, you know, is this instance that I'm aware that that is a possible outcome. So knowing that we have to weigh that and realizing that I am part of that or would be part of that, I think I'd be able to do that, yes.
I guess what we have to be certain of is not you think you could do it, but that you can do it.
Right.
Can you set aside all of your preconceived, opinions or your previous opinions, and can you tell us without equivocation, I can be an unbiased, neutral, fair juror in this case?
Yes, I can.
You were asked a question about it's what we were kind of referring to as the aftermath of Mr. Floyd's death, the protests that happened after, and you were asked whether you believe our community has been negatively or positively affected by these protests, and you wrote positively affected due to the awareness of injustice. Right?
Right.
What's the injustice?
I think there is a lot of police brutality towards certain races, of course. And I think everything that's happened in the aftermath has really shown light and given voice to not just local but national cases that occur.
Okay. So I guess the question again, right? You formed an opinion that what happened to Mr. Floyd was in fact an injustice.
Right.
I understand that you have some previous military service, correct?
I do.
And were deployed internationally as a part of that?
Yes, sir.
And as a part of your military experience, you had training in hand-to-hand combat and chokeholds and things of that nature.
That's correct.
You have a knowledge base that some jurors may not have, right? And the question of police training may come up in this case, and what is trained. Would you recognize that the police training that you have, or excuse me, the military training that you have may be different than what police officers are trained to do?
Yes, I'm aware of that.
And would you be able to kind of abandon your prior personal experience and apply what is trained by the Minneapolis Police Department?
I think abandon, I guess I'm not understanding your question fully, but I'm able to understand what someone else's training is and apply that to the circumstances that they're in, if that's what you're asking.
I am,
Okay.
and I apologize if I'm not articulate. It's been a long morning.
No worries.
You were asked a series of questions that about both Black Lives Matter and Blue Lives Matter, those terms. And with respect to Black Lives Matter, you wrote that you had a somewhat favorable opinion of Black Lives Matter, and you wrote, "I am not completely knowledgeable with the organization. However, it is clear they are trying to make progress towards equality by raising awareness to events." Since you filled this out, any other opinions form about Black Lives Matter?
No, I really haven't been following any other news articles or anything, and haven't really looked into, like I had said on there, I don't really know much about the organization at all, and nothing's really changed since then.
Right, okay. And you had never heard of Blue Lives Matter?
I have never heard of it.
Okay. Do you understand what that means now sitting here today?
I make an assumption that it's, in favor of police officers and protecting them.
Okay. And you just have no opinion of that because you've never heard of it?
Correct.
Okay. So, relevant to questions regarding the presumption of innocence, what you actually wrote was, "I think it would be a little difficult in this case, given the footage that came out and the events that followed, to apply the presumption of innocence."
Right.
So, have you formed an opinion sitting here right now that favors one verdict over the other?
No.
No? I mean, you've got some pretty strongly held opinions, right?
I do.
And you have a negative view of Mr. Chauvin, You believe that he was murdered by the police, right? And you're telling us that you would have a problem applying the presumption of innocence. So again, you know, the only mistake we can make is whether we're, I think as a juror, the only mistake is whether you're, you know, telling us the truth or not, right? And that's what I need to know is, can you take things aside, apply that presumption of innocence, and be fair to Mr. Chauvin?
Right, and again, like I said on there, like I think it's really difficult based off of what I've seen, what I've heard, but also knowing, like, you know, you got to sit there and do the right thing. Then, if I'm like called upon to serve, I take that to heart and need to do what's right, guilty or innocent. So, putting that aside is something that I would internally do, that I just have to follow the right path.
May I have a moment here? We'll exercise it for
Juror 69, we're going to excuse you from this jury. So, in fact, you're excused from all jury service for this term, so you're not going to be called up for another case. Unless, of course, years from now you get a summons. But the deputy will collect some things on the way out, and we appreciate the time you spent here. Thank you. All right, I have that as defense number 11. Is that correct? 11?
Yes.
All right, just some information on our schedule for tomorrow. I granted this defense request to interview the 7 seated jurors, the first 7 rather, regarding whether they were exposed to the information about the $27 million settlement. And we are arranging, we're going to do this by Zoom. I'm not going to make the jurors come in for a 5-minute hearing. So I'm going to do it by Zoom. It's discretionary anyway, so I think I am within the rules to do it by Zoom. The jurors will appear that way, and so by video, and all counsel will be on Zoom. We will just not be broadcasting the video of the juror out to the general public, consistent with our practices here. We've got it scheduled for 8:45. We've heard of from 6 out of 7 of the jurors that they would be available. The examination is going to be only by the court, not by the parties. And we will then discuss each as they tell us what they know and what they've heard. With regard to the other matters, I already denied the request for additional peremptory challenges by the defense. And the motion for a continuance and or a change of venue are still under advisement.
And I believe I had also asked for full sequestration of the jurors during trial.
And at this point, that is denied as well. All right, anything else? Just to give you a heads up for tomorrow. We will, despite the fact we have to talk to those 7 jurors, I think since it's only the court's examination that it might be fairly quick. We're going to summon the jurors for tomorrow morning. We'll bring in another 5 again, but at 9 o'clock so that they are ready to roll by 9:30. And then we'll try and get through as many as we can tomorrow morning. So we'll be summoning 5 in at 9 o'clock and 4 at 1 o'clock, so that they are ready at 9:30 and 1:30 respectively. All right, anything else for the record before we break for lunch? And we'll come back at 1:30 because our other jurors are scheduled to arrive at 1 o'clock, and with the orientation it'll be 1:30. So anything else for the record from the state?
Not from the state, Your Honor.
All right, for the defense.
Sorry, Your Honor.
All right, thank you. We're in recess.
I would suggest to the court that any person who has knowledge of either that settlement amount or the plea negotiations that were the beginning of the case should just be presumed to be biased and be gone. I mean, I ended up having to use a strike on that last juror because he said he would ignore the $27 million judgment. So first of all, Your Honor, I'm asking the court to start the analysis from a presumption of prejudice based on the pretrial publicity. The court in Warren, State of Minnesota versus Warren, which is at 592 Northwest 2D, references that in light of massive unrelenting pretrial publicity, prejudice in a jury pool can be presumed. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered. but we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception, quoting from Shepard. And essentially, Judge, this is what this is what the defense has been complaining about since the beginning of this case. You have elected officials, the governor, the mayor, I'm making incredibly prejudicial statements about my client, about this case. You have the city settling a civil lawsuit for a record amount of money, and the pretrial publicity is just so concerning. And I'm looking at, you know, my remaining strikes, and I'm looking at the fact that we essentially still need 3 sitting jurors plus 2 alternates, and looking forward, virtually every single one of these people is nearly identical to this last person. I've used 11 strikes on people who have had very negative things to say, but they can be fair and impartial, and no matter how you ask them, that's going to be their response here in court. It's the rare person that comes in and says, no, I can't, right? So if we start from the presumption of the prejudice, I think that, and then also take into consideration the sum total of their questionnaires, and the cause becomes the cause challenge becomes a different analysis at that point. So I'm asking for that relief, first and foremost. Second, I'm asking the court under State versus Salas, S-A-L-A-S, 306 Northwest 2D, when someone is aware of the pretrial media, I should be given, at the very least, should be given more latitude, especially about the settlement. More latitude. My latitude was very limited in that last juror and what I was allowed to ask them about their perceptions of the settlement. And in fact, I think the court should be granting me more latitude to inquire about that under these cases. It specifically says, when a juror has been informed of matters through the news media, they'll not automatically support a challenge for cause, but this does not preclude inquiry regarding such exposure, since it might produce a fixed and prejudicial opinion. The court should view such situations with careful scrutiny and permit counsel wide latitude in voir dire inquiry because of the obvious peril to the presumption of innocence in a fair trial.
Is there anything that you felt the court did restrict you from asking about the settlement?
Well, Judge, in the pretrial conference, we had the sidebar where I asked the court specifically how far I was allowed to go. And what I heard, I mean, I wasn't saying that I didn't think that the court denied me the ability to inquire about it, but what I heard the court say was you were going to not let me go too far about it.
I think I said, I think you have a right to go beyond what I had basically said or what they had basically said. But they had heard about it, they didn't think it was going to be a problem for them.
Well, I mean, and I just think ultimately, Judge, I mean, even then in his inquiry, when I asked him about that, he said, well, I guess if I'm not allowed to, I wouldn't talk about it. But again, I don't necessarily think the question is, are they going to talk about it in the jury room? It's what has it done to their perception of the presumption of innocence and proof beyond a reasonable doubt? And so we have a juror who's aware of it. So in the immediate remedy, Judge, I would ask that I be given that strike back and that juror be stricken for cause.
All right. Mr. Slisher, do you want to respond to all of that?
Yes, Your Honor. The state asked the court to deny the relief that's been requested by the defense because there's no reason for it. Once again, it's a solution in desperate search of a problem. I think that this $27 million settlement has been frankly overblown, and I think that that has been displayed in what we've seen so far. First, with respect to the jurors' awareness, right, we've gone through to this point, 14 jurors since the news of the $27 million settlement happened. 14. Out of the 14, only 3 had heard of it. One juror, the first juror, expressed that would cause her to, it would affect her deliberations, right? The second juror was pretty neutral. He was the guy who talked about getting headlines all of the time. It didn't make even enough of an impression upon him to mention in his initial round of questioning. It was just kind of along the list of things and headlines that he scrolled through, something he happened to see. And this third one said he absolutely could set that aside. What the defense is asking for is not a presumption of prejudice. He's asking for a presumption from this court that the jurors, the prospective jurors who he's questioning, are lying to him. I mean, that's what he's essentially asking the court to find. Because these citizens are being placed under oath, they're raising their right hand, they're telling the court what information they've been exposed to and how that information may or may not affect them. And you can see different people have things affect them in different ways. Now we know that there's pretrial publicity in this case, and there has been since the moment the news broke and the Facebook video was released. And it's not because of any conduct of the state or government officials. What I hear him saying is, oh my gosh, we have elected officials doing their job, right? They're making statements. They're talking to their constituents. In the case of the city, they settled a civil claim because they felt apparently they needed to do so. That the government, the state, I should say, this prosecution team, again, has absolutely no control over that, nor should we be meddling in some other instance I could see where you could find fault if we were trying to control the flow of information or the outcome of the civil case. They need to do their jobs. We need to do our jobs, and we all need to stay in our respective lanes. This is one of those situations where the cure is the saying, don't just do something, stand there. And that's what you exactly need to do here. We have a process of voir dire that we put people under oath, and we ask them questions, and we get their answers. And on an individual and a particularized basis, the court, in its discretion, makes the determination as to whether or not the person should be stricken for cause or not. And we're on day 6, right? In this day 6 of jury selection, of which you had 3 weeks slotted, we have plenty of time. We have, 329 prospective jurors have been identified in this case. And we're through, what's the number we're through now? We're below 100. We have plenty of time. We have plenty of people. We can take all the time questioning that we need to determine on an individual and particularized basis whether there's prejudice to the defendant or a need to strike people for cause. That just hasn't borne out so far, and I don't think that we should overreact to what's been happening. This case is in the news. It's going to continue to be in the news. There will be a story about this case every single day, no matter what. That is going to happen. And what our job here is to determine whether the particular prospective jurors in the box have been exposed to media, if they have biases that they can't set aside, right? That's what our job is. But it's not to make a prejudgment as to the rest of the panel. As to the last juror, the defendant doesn't need to strike back in that particular instance because the juror did not demonstrate any reason to strike him for cause. He stated, and it was a considered opinion, and you saw him, right? I mean, you're observing him as he's talking. I understand he was masked that whole time, but the sincerity with which and the contemplativeness with which he gave his answer that, you know, I could set that aside because that's my job, because that's my duty, and that's what I would do. And this particular juror is the one who would know a little bit about that, having previously deployed as a member of the Minnesota National Guard and knowing that sometimes things are hard, but you're supposed to do it, so you do it anyway. He stated that under oath. There is no reason to disbelieve him, and the court should deny the defendant's relief.
Well, a couple things. I probably was not as articulate as Mr. Nelson was when I mentioned the concern about the plea bargaining, the concern about the $27 million. But I pretty much said that it's going to be a quick road to a challenge for cause. Maybe, so that's saying I'm presuming prejudice in those. But I don't think I can listen to a juror who says, I can be fair and impartial. Yeah, I was aware of that. And to be honest, our last juror, I don't think he was lying when he said that settlement thing, I don't think that would affect me at all. I think it was more maybe perhaps a lack of introspection about the other firmly held beliefs that he had. He had a very negative opinion about the defendant and a variety of other things. And I don't think he was intentionally lying. I think it's true of a fair number of jurors. They just lack the introspection to say, yeah, I don't think I can be fair and impartial. Some have not. I don't think I have to accept a juror's statement, I will be fair and impartial, when everything I see, the totality of the circumstances, is they can't be. It's almost humanly impossible given the opinions they hold. And if they are confirmed that they still hold those opinions today, and they are that strong, and considering everything, I don't believe that's true. I think it's appropriate that I accept the challenge for cause. The state might push back and say, if they say they can be fair and impartial, you have to accept that. I don't think so. I think part of my job in a challenge for cause is to make a determination if they could be fair and impartial, not just did they say the magic words. So I guess I think I'm almost between the two positions here. This has always been my thought, that I have to consider everything listening to this juror, whether there is a challenge for cause or not, based on the totality, not just the words that come out of their mouth. Those are important, obviously. And if they say, I can't, just not very self-aware, and it's very clear that they are not self-aware.
I think that's perfectly appropriate. I do want to just mention, you mentioned the third degree, the plea negotiations. Of all of the jurors we've examined so far, if my notes are accurate, we've had one state that they had any sort of awareness of that out of everyone, and that person was stricken for cause. Again, that's perfectly appropriate. We have a lot of jurors to go through. We have a lot of time to go through them. And that's the process that we can use to ensure this defendant a fair trial.
All right. Mr. Nelson, anything else? Or? All right. I'm going to deny the request to reinstate a peremptory challenge, but your observations are noted, and I think they're actually consistent, but feel free to argue strenuously in certain cases, knowing that my standard is not, they said the magic words. Okay?
Understood.
All right, let's move forward then with the next juror. Is Juror 71. Juror 70, I believe, is the one who has postponed their service.
They need to be the group. I don't think this group has done.
Oh, that's right. We're back to the... It's the group. We need the group, all right. Thank you for reminding me.